Hello students, welcome to 1 PYQ, a day series of law optional. Today again we have come up with one very important question which was asked in the year 2025 by UPSC. Now you see this question, it was a 10 marker question. That means you have to answer this in 100 to 150 words around, and the question is asking about article 143 of the Indian Constitution. Now let's read the question. Critically examine with the help of decided cases the power of the President to consult the Supreme Court. Now the power of the President to consult the Supreme Court is the power given to the President of the country to obtain a legal opinion of the Supreme Court on any matter of law or fact, and this power is provided to the President under Article 143 of the Indian Constitution. Now there are two clauses which are there in Article 143 of the Indian Constitution, and we are going to see both of them. Now see, look, first, if any kind of opinion on any law or fact is asked by the President from the Supreme Court of India, then the Supreme Court is not bound to answer. Now that is what is written in first number 1 clause. Not binding on the, it's not compulsory. Not compulsory for the Supreme Court to give its opinion. It can give the opinion on anything related with facts, related with law, but the word may has been used, not the word shall. Word may. Supreme Court may give its opinion. Now coming on to the second one. Any question is asked about any fact or any law regarding anything which has happened in the pre-constitutional era. That means before the commencement of the Indian Constitution. Any treaty may have happened, any agreement may have happened. And if there is any fact or law on which the President of the country wants some opinion of the Supreme Court, then the Supreme Court has to give. The word shall is used. The Supreme Court has to give the opinion. This is clause number 2 of Article 143. So it is very simple. There are two case scenarios. One is after the commencement of the Constitution and before the commencement of the Constitution. When it is about after the commencement of the Constitution, any question of law or fact, if the President wants opinion of the Supreme Court may give the opinion and may not give the opinion. The other thing, before the commencement of the Indian Constitution, if some question of fact or law arises which relates to some kind of agreement or some kind of sanad which has happened before the commencement of the Constitution, that it becomes compulsory for the Supreme Court to provide its opinion. You must remember these two important words. Supreme Court may give its opinion or Supreme Court shall give its opinion. Now the question arises whether after the opinion is given by the Supreme Court, whether it is compulsory for the President to adhere to that opinion. The answer is no. Now the question here is also asking about the decided cases. So let's discuss several decided cases. Now I have made a list, and there are three kind of categories which I have come up with, and let's talk about these categories and the cases which relates to these categories, and all of them are related to Article 143 of the Indian Constitution. Now, is the court bound to answer? Again, there have been two cases where it was said by the Supreme Court of the country that the court is not bound to answer when it relates to clause number 1 of Article 143. It is not binding on the court. But if the court is refusing to answer, then some kind of compelling reason must be given, some kind of cogent reason must be given. Court should not just come up and say that I don't want or we don't want to answer this particular question. Some kind of compelling reason has to be given, and a compelling reason was definitely given in this case, M. Ismail Farooqi versus Union of India case 1991. This case relates to the Ram Janmabhoomi Ayodhya case, and the simple question was whether the temple existed before the mosque or not. Supreme Court refused to give its opinion on this matter, and it was a very compelling reason that it can create some kind of animosity between one religion, against one religion, and between two religions, I would say. So this is category number 1. Let's go to category number 2. Can the President ignore the advice? If the advice is given by the Supreme Court of the country, the opinion is given. Can the Supreme Court ignore it? You know, the Kerala Education Bill of 1958 answers this. It says that it is not binding on the president. Simply means the president can refuse to adhere to that advice. The Supreme Court may not follow the advice. It does not matter whether the advice has been given on any matter which has happened after the commencement of the constitution, or for that matter even before the commencement of the constitution. That means under Article 143 clause 1 or under Article 143 clause 2, if any opinion is given by the Supreme Court to the president is not bound to follow that. That is what is said in the Kerala Education Bill 1958. Now, a third kind of very interesting and curious question comes up. It is not binding on the president, of course, but does it bind other courts? Because the opinion under Article 143 is given by the Supreme Court of the country. So, is it binding on high courts? Is it binding on subordinate courts? That's the question. Now, you must understand, it's an opinion. It's not a law. It's not a judgment given by the Supreme Court of India. If you see Article 141 of the Indian Constitution, it clearly says that any judgment which is given by the Supreme Court of India is binding on all the lower courts, the high courts, the subordinate courts. But this is not a judgment given by the Supreme Court of India. Rather, this is the opinion given under Article 143. Okay, so that is the reason why you cannot call it to be binding on all the court, but it have very high persuasive value. So almost we can say it's binding. The high courts does not want and does not go against the opinion given by the Supreme Court. It has very high persuasive value. So these are the decided cases, and these are different categories under which we can keep those cases which relates to the president's power to consult the Supreme Court under Article 143 of the Indian Constitution. This is how you have to manage to write it. Now, you can write the introduction also and you can write the conclusion also. So, I always say, well, writing the introduction, there can be multiple introductions which you can give to this question. The introductions always have to be very specific. You must write something very specific related to this particular question. And, you know, at last, the conclusion can be broader. In conclusion, you can also write the way forward, or you can write your opinion also. So this is how you have to approach this question. You must know the material which you have to write within it. You must know about the article, the clauses of that article, and you must also know about the cases related with that particular provision. So thank you very much for joining me. Have a nice day and Jai Hind.